going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Hope you're having a great day so far. Happy Wednesday. It's Wednesday, right? Yeah, it's Wednesday. Is it Thursday? Day? I don't know. Happy whatever day it is. It's Thursday. It's Thursday. Okay, I just double checked. Anyways, happy Thursday. Sorry I'm a little bit late. I can't play a video on my secondary hard drive. I've tried it before and it doesn't let me do it. And I forgot, and this is a really big video, so I had to move it back over to my primary disk. So it took a minute, so I do apologize. Anyways, we are starting off where we left off last night. We're in Judge Clark's courtroom in a post-conviction hearing, and tonight it gets really interesting. So hopefully you guys have your popcorn ready. We have the former defense attorney on the stand, and yeah, he's not too happy. The new defense isn't too happy. The prosecution isn't too happy. You know what? Judge has to step in a few times and has to calm these people down. This is when it's good, and this is why I'm playing this. So, yeah, that's what we have tonight. Anyways, Legal Fiction, thank you so much for the super chat. Late fee. I think I need a super chat. I was late. 2 nights in a row. I'm a very punctual person. I don't like being late, so I do apologize for that. And Legal Fiction, thank you so much. And LZ8er, thank you so much for the 15 months. That is awesome. Thank you so much, LZ8er. Do appreciate it. And Nenya Business for the 20 months. Enjoy. You're always good to watch. Yeah, words are hard. Thank you. And I appreciate you being here. Thank you so much for the 20 months. That is amazing. Thank you so much. All right. You guys ready to go? I'm ready to go. Before I hit that play button, you know what to do. Hold on. I actually have to I have to let that play my intro first. So I got to go. We're at 106.25. Okay. Right before. Okay. We're good here. We're good. All right. Let's just go. You guys know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Stanley Peacock, Judge.
Peacock?
Sir. May I take this with you?
Yes, sir.
I do.
All right, Mr. Peacock, you have a seat.
I don't think we need to bring Colonel Mustard. I think we have Peacock in the courtroom with the beard. I think that's the winning solution for this one. That beard is epic. Look at that thing. I'm so jealous of that man right now.
Speaking to the microphone, you may inquire whenever you're ready.
Thank you, Judge. Good morning, Mr. Peacock. How are you today?
Good morning.
How are you doing?
I said, good morning. I'm fine.
Oh, I didn't hear your phone. I apologize. Do you recall representing Brian Miley?
I do.
Okay, and this is a case that ultimately went to trial?
It did.
Okay. Did you discuss Mr. Miley testifying on his own behalf?
I did.
Okay, and what was your advice to Mr. Miley in regards to that issue?
Well, I told him that because he had a history of 20 felony convictions in Jackson County for burglary and grand theft, it would probably not be a good idea for him to testify.
Did all those convictions happen on one day?
I don't believe so. I don't have every date of every charge, but I don't believe the 20 different cases all happened.
Yeah, kinda. How do I recap last night? I'm sure the chat can help a little bit. So this is a post-conviction hearing. This guy was convicted of, I don't even remember what he was convicted of. I said this last night that I needed to do a little bit more research in what was going on because I'm kind of clueless. It's just a very interesting case to watch. But this is a post conviction. He's already been in trial and he was already convicted of of the charges against him. Now they're back and he has a new defense attorney. They questioned two of the co-defendants in the last video. So you kind of got an idea what was going on. It's a drug case. There's a bunch of different charges. The drugs and theft. Child locks were involved. Yeah, a lot of weird things were happening. And so I don't know if I can recap what happened last night, but assault too, Phil? I don't remember the assault. Okay. All right. There's a lot going on here. Let's go.
But on the same day.
Okay. If they all did happen on one day, would that affect your assessment?
No,
Did you ever consider the fact that you could preemptively talk to the jury about this was one bad night for Mr. Miley and these 20 convictions arose from that one bad night?
my experience has been if you committed 20 felonies over a period of time, or if you committed 20 felonies on one exact day, that would still be not helpful to you in a felony jury trial.
Okay. Now, keeping that in mind, would it be necessary, despite that issue of the prior felony convictions, for Mr. Miley to testify if he was the only one that could provide the defense in the trial?
I'd have to discuss the dynamics of that with him and how many people were involved, like all of his co-defendants, for example.
Okay.
The facts of the case would determine how we would proceed with our strategy.
Did you discuss the independent act defense with him?
I discussed that there was no viable defense because of the combination of behavior which exhibited the elements of kidnapping and exhibited the elements of basically a robbery.
All right, so that wasn't my question. My question was.
That's the answer to the question.
I don't believe it did. My question is, did you specifically discuss the independent act defense with him?
I don't recall using the independent element of what you're talking about, but I do.
This is already starting off good. That wasn't the question I asked you. That was the answer I gave you. I'm telling you. You can slice this tension. Let's go.
Do recall discussing the facts and circumstances in the police record.
Do you know what the independent act defense is?
I believe it has three elements. I think you've outlined it sufficiently in your motion.
All right.
I believe it's the
Explain
Foss
to the court what an
case.
independent act defense is.
You have to prove that each of the elements of kidnapping and or the robbery are all matched up. They all exist. If you don't, then you have a positive defense. That's the basic street level summary of it.
Okay. So if Mr. Miley were to testify, because I'm not quite sure I understand your explanation, what would he say that would qualify as an independent act defense?
You're asking me to say what this man would say? I can't do that. I don't know what he would say because he said multiple things to multiple people.
Okay. So you don't know what an independent act defense would look like in this case?
I know that the elements of kidnapping and the elements of a robbery exist in the facts that were testified to, not only by him, but by the other victim. The other person that's the victim here, Mr. Porter.
So I asked you about independent act defense, and you told me about how the facts supported the evidence against him. Is that what you're saying?
The jury thought so.
All right. So instead of answering my question, you're just going on about your assessment of the evidence. Is that fair to say?
I gave him my educated knowledge of what was in the report.
Biggin, thank you so much for the raid, my friend. I appreciate it. That is awesome. We are mid-hearing here. We started part 1 last night. This is a post-conviction hearing, and we are now questioning the former defense attorney. And yeah, we have a case. I'm going to try to give a quick update or a quick summary of what happened, but the defendant plus a couple other people were at someone's house random one night, I don't know, a while back, and they decided to buy some drugs. So they went to an ATM machine, and then they decided to rob somebody. And a lot of things went down. There are a bunch of co-defendants, a lot of things happening. This guy was convicted. I don't know if they said, I think they said a jury trial. He was convicted at a jury trial. Now they're trying to bring up new evidence. So this is a post-conviction hearing. The guy on the stand right now is the defense attorney that defended this guy at the jury trial. Now he's got a new defense team, and they're questioning him, and it gets a little spicy. That's what's going on. But Biggin, thank you so much for the raid. I do appreciate it. Welcome to the Raiders. And yeah, Uncle Dan, we've already decided that this guy's your brother, just so you know. Just so you're aware, he's your brother, Dan.
Reports and what the witnesses said. I advised him, due to 20 felony convictions and 3.5 years in prison, recently released, that it would be in his best interest at that time not to testify.
Did you argue independent defense at the trial in your closing?
Those specific terms were not argued.
Was the concept argued?
The facts were argued, sir.
Okay, my question is, when I said, did you argue the independent act defense, and you said not specifically the term, so I said conceptually, did you argue it to the jury?
Conceptually, I argued the facts and testimony in the case.
Okay. Maybe I'll just show you the transcript and maybe we can get to an answer here. I'm referencing page 218 in the trial transcript. Probably starting from here, line 20. If I show you a copy of the transcript, would that refresh your recollection of whether or not you argued independent act to the jury?
I need to see the transcript, sir. It's been, I think, 8 years.
Okay. May I approach?
You may approach.
Thank you. I'm going to show you starting from line 20.
8 years? Did he just say it's been 8 years? This is blowing my mind. They keep adding things to this case that 8 years. What is going on here? None of your business. Thank you so much for the 10 gifted memberships. I appreciate it. Welcome to the 8 new members. I got 8 years in my head. Welcome to the 10 new members. Thank you so much. None of your business. Wow, this case.
Your blue line marks start with line 19 and ends at line 23. Is that what we're talking about?
Sure. Yeah.
Okay.
No. This hearing, this trial happened last week. It happened, I think, Friday. So it sounds like if the conviction happened, the jury trial happened 8 years ago. That's what Mr. Peacock just said. But no, this is not 8 years old.
So after reading that, do you believe you tried to argue independent act defense to the jury?
I don't know what the jury thought, but I argued the facts of the case.
Okay. I'm not asking what the jury thought. I'm asking, is that what you were attempting to do when you made that argument?
I was simply arguing what the facts of the case are, sir. And I believe if you continue and look at the rest of the arguments in the statement, that it validates the argument I tried to make for him.
Okay. So I'm going to read to you what you argued there. Starting from line 20 on page 218.
It's line 19, sir. That's what you marked with your blue pen.
I'm reading from line 20. We got a drug dealer that snatched some money out of the hand of one party. That's your reference, Mr. Porter's, the drug dealer. And someone else in the ballgame decided to take it under their own power and their own control, and it got out of hand. So when I read that, it seems to me you're arguing, listen, this is what originally was happening, was a drug deal, and then someone else in the vehicle decided to get involved and do something different. Would that be fair to say?
I was an attorney representing my client, and I got the testimony in the trial that supported what I just said. They couldn't figure out at one point who snatched money and who delivered money. And as his attorney at the time, my purpose was to have whoever the other parties were to be conceived or thought of by the jury as the badder guy than my client.
Right, so the concept of independent act would be, my client, Mr. Miley, showed up there for a drug deal. The money was given, which is Mr. Miley's role, and then all of a sudden, whatever happened in the back seat happened, and that was outside.
All right. We have a 24-month anniversary. Every anniversary gets an instant pause. Thank you so much, Shashina. Good, so good to see you. Thank you so much for the 2 years. That is awesome, Shashina. Thank you. Hopefully you're doing well. It's good to see you tonight. It's so good to see you. We got Phil. Thank you for the super chat. Late fee for Tammy. Thank you so much, Phil. And good to see you, Tammy. Phil, late fee for Jedi. Okay. Thank you, Phil, again for the late fee. I do appreciate it. And Cheshire Cat. Cheshire Card approved. Thank you, Cheshire Card. Cheshire Card. Wow. I'm going to start calling you that instead of Cheshire Cat. Thank you for the super chat. You guys are awesome.
Of what Mr. Miley intended and was there to do.
As his defense attorney, that was my purpose.
All right. So in that's essentially, would you agree with me, an independent act? You show up for one purpose and someone else with you decides to do something completely different than what was planned.
That was the presented argument, and that's what he chose to argue when I interviewed him.
Okay. Now, wouldn't it be necessary to have Mr. Miley testify in order to support that proposition? Otherwise, what you argued was just your conjecture of what happened.
No, he didn't have to.
What was the evidentiary basis for you to make that argument?
There was some confusion in the back seat about who did what to whom. There was confusion about who was beating on whom. At one point, there was some statement in affidavits that even my client, who was in the front seat, may have entered into the pummeling or beating of Mr. Porter. And there were at least 2 other guys in the back seat. One of them was what I'll call the muscle guy, the guy who's just been testifying here earlier. And basically, the exchange and the beating had happened in the back seat. I was trying to draw the analogy that if my client is in the front seat, it'd be difficult for him to turn and hit or have physical fighting with the alleged victim.
Okay. So the state's case was the victim and the co-defendant, saying that Mr. Miley was part of this. And in order for you to present an independent act defense, you have to present your own assertive evidence to show that it didn't happen like this. It happened like this.
I made the argument that my client presented to me, and I made it without putting him on the stand because of his 20 felony convictions.
Okay. Do you recall how Mr. Overstreet rebutted your argument in his rebuttal closing?
I'm confident that he did, but no, it's been 8 years. I'm not familiar with how Mr. Overstreet rebutted.
If I showed you a copy of the transcript, would that refresh your recollection?
It might.
All right. I'm going to show you what's marked page 219 from line 22. May I approach, Judge?
You may approach.
Are you including the continuation of Mr. Overstreet's argument on the next page?
Sure, you can read on to the next page if you want.
Mr. Overstreet was doing his job. He was countering the argument.
And how did you counter your argument?
Well, the record speaks for itself.
All right.
For him, the record speaks for him.
So I'm going to read it, line 22. Mr. Peacock from page 219. Mr. Peacock said, well, someone else took it upon themselves after he snatched them up, which is his, essentially, he's referring now to the independent act defense. Again, so what? So they get to beat him up, take him around, go through his pockets, take his stuff because he's hoping that, of course, who's going to believe this guy because he's dealing drugs? What a horrible human being. Nobody's above the law. He's going on to say it's irrelevant because he's arguing principle theory throughout this, right? They all went in. It was all planned because all the evidence was all that it was planned at the apartment, the child lock, they came in and did it. Isn't that correct?
No, I think you're adding to what Mr. Overstreet argued in your interpretation.
Not in that part, but I'm arguing the state's case as a whole, that this was premeditated, and the premeditation started at the apartment when Grant Jones says a lick happened, and then the premeditation continued when they presented evidence of Mr. Miley getting out, child loss, right? That was all premeditation, right?
When you combine what Mr. Jones said,
Yes.
sounds like premeditation to me when they're talking about a lick in Mariana. They get in a car together, all of them together for an hour and drive down to Panama City. Yeah, sounds like.
So had you presented evidence against that in showing that, number one, no one said there was a lick. Number two, Mr. Miley didn't get out and lock these child locks. And number three, Mr. Miley himself saying, I didn't participate in this. This was just a drug deal. And then something happened outside of that scope that I was not involved. That would have been a different thing, correct?
I think you're adding to or trying to conflict between the statements about who got out and who did what. I think the jury made their decision based on the testimony and evidence that was presented.
Yeah, that's why we're here today, because our argument is you didn't present the requisite testimony that would have had an impact on this jury, and by virtue of not doing that, there was a deficiency and you prejudiced Mr. Miley. Yes, that's exactly why we're here today. So
That is
now
not
we're
correct.
getting into why you did these things. So I'm still on step one, why you advised Mr. Miley not to testify if he was the only way to establish an independent act defense, which I'm not sure you quite understand. So let's get back to whether or not you understand it, because I don't think you can explain it to a jury or advise Mr. Miley on testifying if you yourself can't explain it. So I'm going to ask you this again. If Mr. Miley, who you seem to be saying is testifying that he didn't get involved in this and he's only a drug deal, what would you need him to say on the stand to a jury to establish an independent act defense?
We decided not for him to testify based on what I've outlined to you already, sir.
Okay, so I'm going to take it from now. You just saw the 20 convictions and you gave up on the concept of him testifying.
No.
Despite the fact that it was necessary for him to establish a defense. Is that fair to say?
No,
No, why not?
because the jury heard what they heard with the witnesses that were there. All the other attorneys on the other co-defendants were basically doing what criminal defense attorney should be doing for people that are their client. They're giving them good legal advice not to testify. And I believe that that was pretty much the attitude of Konwinski. It was the attitude of.
So we can't get into what other people were doing. We're talking about why you gave this advice. And my question is, did you fundamentally believe that Mr. Miley needed to testify in order to establish an independent act defense?
I did not.
Okay. So if he didn't testify to establish that, did you see?
Thank you, Dan. I was thinking that exact same thing. Why is the defense attorney? This is the defense witness. They called him, and he keeps interrupting them every time he's. I don't know, not every question, but a lot of the questions he's stopping them from answering. I was going to ask if that's normal. I don't want you to say too much, so I'm going to interrupt you. Come on, give him some respect. He's an attorney.
Another way to argue an independent act defense.
We argued the evidence that we had, and we argued it with what was said, and the jury decided that he was guilty of participating in a robbery and a kidnapping.
Okay, so I asked you, do you have an alternative way to prove it other than Mr. Miley testifying?
I'm gonna sustain the objection. I think this has been covered pretty well in the last 10 to 15 minutes.
Okay. Maybe the both of you heard an answer, but I'll move on.
I don't need any commentary, sir.
All right, Judge. So let's get to.
For the record, I think you were getting the same answer every time you asked the question, whether it's the answer to that you wanted or the answer was responsive. It's the same answer that was given to the same question that was asked at least more than once. So I don't know how you can rephrase it to get a different answer, but I think the record's pretty clear that the same question was answered and the same question was asked and the same answer by Mr. Peacock was given.
I agree with that, Judge.
Okay.
But I don't agree that the answer was responsive. I guess that's where we disagree, Judge.
I'm not saying it was responsive or not. I'm saying it was the same answer given to the same question that was asked more than once.
Yeah, sorry, you didn't get the answer you wanted. He's an attorney. He's not going to force feed you what you want to hear. His credibility's on the line right now. I mean, he's not going to get in trouble for this, but at least I don't think he will. But yeah, he's not going to force feed you what you want to hear. He's there under subpoena, and that's an epic beard. He's taken away from taking care of that beard right now for a case that he doesn't remember from 8 years ago. Drop the attitude.
That's
But
correct.
you want to ask a different question or a different way, but let's move on.
Okay. Do you know who Julia Kahida? Do you know who she is?
The attorney's not necessarily on trial. He's a witness, and they're trying to bring in new evidence to this case to hopefully help this defendant. But he's already been convicted of assault, kidnapping, some kind of drug charge. So he sounds like he's going to be in jail for a little bit. But he's got this new team of lawyers, and they called in his public defender. Mr. Peacock's a public defender. So they're drilling him these questions, and he's doing a great job just maintaining on the stand. My hat's off for him.
I know of her.
Okay.
Mhm.
Did Mr. Miley tell you about her?
I believe he did.
Okay, and what did he tell you about her?
I don't recall the specifics.
Okay. Did he tell you that she was there at his mother's house where everyone was gathered prior to going to Mr. Porter's?
Yes, and she told me everybody. He told me that she, along with others, were high as a kite.
Okay. Did he tell you that well, when you say that, so I guess you're putting some commentary that everyone was high. Also, that includes.
Everyone was high, sir.
Okay.
That was what he reported to
Peacock,
me.
wait for it. This is going to take a long time if you're going to testify without a question. So let's wait for a question.
Grant Jones was also in the vehicle and he was high, correct?
I believe he advised me of that, yes.
Okay. And the state used that same witness in the trial, correct?
I believe they did.
Okay. Well, you were at the trial. They used.
I attended part of it. I do have other clients, and I was not in every moment of the trial involving
Mr. Miley's trial.
Mr. Miley? Yes.
Yes. They called Grant Jones, is that correct?
Say that again?
The state called Grant Jones, who testified he was high during the whole event on the state's behalf, correct?
Correct. And he verified that everybody was high, I believe, at the
Okay.
house of his mother.
Well, I say that to kind of respond to you when you say, well, everyone was high. Well, the state used a high witness and got a conviction. So that doesn't necessarily mean because someone's high, they're worthless as a witness, is what I'm saying. Is that fair to say?
It's fair to say that any witness could be called.
Okay, that's not what I asked, but okay. Did you speak to Julia Kahida?
I'm not sure if I did or not.
Okay.
I did speak to his mother to confirm at some point on the phone some of the people that were involved.
Okay. So do you have any recollection of speaking to her and interviewing her of what happened and what, if anything, she could add to your client's case?
You're talking about Kahia?
Yes.
I don't recall.
Okay. When you speak to potential witnesses in a case, do you take notes on that?
I usually do.
Prior to coming here, did you review your notes in this case?
I reviewed the notes that were available to me. Yes,
Okay. And when you say available to you, they're your own.
they are my
right?
notes. Yes.
Okay. In those notes, did you show anywhere of making contact with Julia Kahida and discussing this case with her?
I don't recall that. Okay. And I haven't reviewed every note that I ever had. A lot of my notes are in storage.
Did you pull those notes for today's hearing?
If they existed, I could pull them. Yes. But usually after 7 years, things are able to be destroyed with the Florida bar.
Okay, so I didn't hear the answer. I asked, did you pull the file prior to the hearing today and review the file?
No.
If Ms. Haida was able to come in, if her testimony was, I was there that night at Miss Miley's, the mother's house, and no one said anything about a robbery, no one said anything about committing a lick, would you have called her as a witness on behalf of Mr. Miley?
I would have certainly considered it and talked to my client about it.
Okay. Do you see any negative in not calling her? In calling her.
Based on what I heard from her today, I mean, that may or may not have been a possibility. But if everybody was high at the house and I discussed that with him, which I did, I didn't think that was going to help him any.
Okay. Did you speak to Cheyenne Bentley?
I don't recall that. She had a lawyer, and I know that lawyer. I know all the lawyers on the other side. I've known them for years. Their advice was to keep your mouth shut, not say anything, basically.
Okay. When you say that, did you speak to Cheyenne Bentley's lawyer and say, I want to interview your client as a potential witness for Mr. Miley?
I don't recall doing that. I wouldn't normally see her attorney, except in the courthouse and in the courtroom and in passing. And I make a practice in the courthouse. I don't discuss cases with anybody else listening in the courthouse other than my client.
Did Mr. Miley tell you that Cheyenne Bentley could be a witness on his behalf?
I don't recall that.
Did he tell you Sean McDuffie could be a witness on his behalf?
I think he may have,
Okay.
but in looking at him and his background and his lawyer telling him not to say anything, that short-circuited that option.
Okay, when you say it's short-circuited,
But
did you?
Sparkle Boots, thank you so much for the super chat. Permission requested to clock the attorney questioning the witness. You know, sometimes I wish there were clocks for criminal cases. There's not. But a lot of the appellate cases, they have clocks. They have to ask their questions in a specific amount of time and make their case in a specific amount of time. I don't think they do for a lot of criminal cases. Maybe there are some. I don't know. Dan's here. Dan can tell us. He's civil, but he can still tell us. Dan, is there a clock for criminal cases? Let us know.
I'm not going to approach him without permission of that attorney.
Did you speak to his attorney?
I think we may have in passing, but I don't independently recall that.
Do you have notes to say you spoke to his attorney?
I don't think so.
Yeah, now that makes a lot more sense. That makes more sense. I was answering it practically, but it's the Sparkle Poots we're talking about. So yeah, no, she wants to smack him. Okay, fair. I'll grant that permission. You can do that, Sparkle.
Okay. And what did his attorney tell you?
I don't recall his attorney telling me anything other than we saw each other in court occasionally and realized that, you know, there were people that we had in common with the event.
Okay, so you never spoke to his attorney to say, I want to speak to Sean McDuffie because my client has informed me he is willing to testify on his behalf and I'd like to interview him as a potential witness on my client's behalf.
I don't recall that kind of conversation ever happening.
Okay, why did you have that type of conversation?
Because I don't discuss cases or facts in the hallway of the courthouse about anybody. I even advise my clients, we need to stop talking now because there are people in the hallway.
Okay, why didn't you make a phone call to that effect?
I don't recall if I did or not.
Okay.
I do know that those lawyers have a pretty standard practice with this many convicted felons that you don't usually let that guy start talking in another case or any other investigation.
Okay, did you email his attorney saying, I want to talk to your client because Mr. Miley has said he's going to be a witness for me and I'd like to talk to him?
I don't recall that.
Okay, but you have an email, if that were the case, record of it.
My email works.
Okay, but you don't have such an email, do you?
I don't recall having email conversations with any of the other co-defendant attorneys.
Did you do any research on the 2010 Honda Civic and how the locking system works?
I did not.
Did you discuss the locking mechanism with?
Oh, Jen, I love the reference. Come on. They call me Tim. Cow, 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 cow. That was me throwing lightning. It was. Thank you for that. That made me giggle.
Mr. Miley at any point?
I believe that subject came up, but I don't recall him being, you know, scientifically or absolutely knowledgeable about it.
Okay, so he brought it up to you.
I believe he may have brought it up in the transition of who got in and who got out and all the different arguments. But no, I did not do the research on the door and whether it locked or not.
Why not?
It was not relevant to what I thought was going to happen, because if it was him or if it was one of the other parties that understood the locking mechanism, then that's how it happened.
Okay. So why don't you think it's relevant? Because there could have been an argument to say that the state's testimony about the locking mechanism was indeed false, and that Grant Jones gave false testimony, and what really happened is there's a default locking mechanism that could lead someone to believe that the doors were locked.
I don't believe that you gave any estimate or document testimony today that said anything was incorrectly operated or not operating correctly. I heard testimony that the door locked whenever she drove away.
Right.
Mo, that's a great question. I don't know. I'm assuming that this is probably a paid attorney. I don't know if, I don't know. I would just, I don't think another public defender would be throwing another public defender under the bus like this. So I'm going to guess it's paid. But I honestly don't know. I don't think they say it all throughout this case.
And I heard that it's easy to open the door if you know where the switch is next to the door. That's what I heard. I didn't hear anything about it being faulty.
I'm not saying it's faulty. The argument is on this model of car, once you hit, I believe, 9 miles an hour, everything
Are you going to testify now?
Let me finish so you understand, because I don't think you understood the proposition. That once you hit 9 miles an hour, the door's locked. And the way to open them, because you can't open them once they're locked, you have to manually unlock them. And the unlock is a tab that moves left to right, and it is blended into the door, and that many people don't see that. So they keep trying to open it, the door handle, without realizing where the lock is to open.
It sounds like you're making an argument after the fact, years later, that something happened that there wasn't any proof of that at the time, other than there were people that opened the door and people that closed it.
Yes, again, I am making an argument after the fact that you should have made it to the trial and you had access to by way of Cheyenne Bentley.
Hold on just a second. I'll overrule the objection, but just ask your question. And Mr. Peacock, if you can answer, and let's move on.
Okay, you had access to Cheyenne Bentley, and you had access to a manual that your client told you about, that this is a concept that's self-locking. You could have easily gone online, looked and see, well, how does this door lock look and how does it operate? You could have done the legwork and found that out. Is that correct?
I have no legal access to Cheyenne Bentley in this case. She was represented by a counsel. I had no access to her that way. I knew he told me they were romantically involved. And he felt like she would never say anything bad about him. I know that he said that.
Okay.
And I can say that now because the attorney-client privilege is capable of being violated in these kind of hearings when I'm being the accused person. So I'm telling you, he had a romantic relationship with that lady and made a point of saying that she would never do anything bad about him.
Okay, so it's my understanding that you believe if someone is represented by a lawyer, you have no access to them.
Unless you get the attorney permission to do so.
Okay, and you could have done that with Cheyenne Bentley.
I could have asked.
Yes. Okay, and it could have been granted, right?
I don't know that.
I'm not saying whether you're speculating on whether that attorney would allow it or not, but conceptually, you can ask an attorney, can I speak to your client? And that attorney can say,
Conceptually, that's true, but my client did not wish to involve her any further.
okay. He told you don't.
He said he didn't want to involve her any further.
Okay. And as far as the locking mechanism, car manuals are available online. Is that fair to say?
That is accurate.
Okay. You attended part of Sean McDuffie's trial, correct?
I attended those portions where I was not in court on other matters. Yes, I did not attend every minute.
All right. And in that trial,
By the way, the
Hold on, speak up. Just wait for a question.
in that trial, the judge did not allow the statement of, we're going to do a lick to come in. Is that correct?
I'm not sure. I wasn't there for all of it.
Okay. Mr. McDuffie's trial happened prior to Mr. Myers.
I'd like to bring to your attention, your motion file gave the wrong trial date.
Okay.
Speak up, just answer the question. Now,
Yes,
I look, listen.
Yes, sir.
No, I just wait for a question, answer the question the best you can, then wait for the next question. I don't need any more commentary from anybody. Ask your question.
Thank you, Judge. So Mr. McDuffie's trial happened prior to Mr. Myers.
Correct.
And you knew Mr. McDuffie's attorney, correct?
Correct.
So any questions or issues you would have had of what happened to that trial, you had access to that attorney, you could ask them what happened on this issue or what happened there. Is that fair to say?
I could have done that. Yes.
Okay. Now, what Grant Jones is going to testify to, or what James Porter is going to testify to in Mr. McDuffie's trial, could be impactful, right, to what happens in Mr. Miley's trial.
That is precise. That is correct. That's precisely the reason I tried to attend as much of it as I could.
Okay. Now, the issue of hearing of Grant Jones' testimony on a lick happened, that was an important fact in the case. Is that correct?
It was an important factor.
Okay. And if it had not been admissible in Mr. McDuffie's trial, that would have been important for you to know, correct?
Yes.
Okay. Did you know it was inadmissible in Mr. McDuffie's trial?
I don't independently recall that.
Okay. If you knew that, would you have not tried to make the same argument in Mr. Miley's trial as well?
It would have been helpful.
All right. And would it not also impacted you if the prosecutor in the case said that Grant Jones didn't know who made that statement?
That would have been helpful.
All right. And why would it have been helpful?
Well, it would create confusion and doubt in the jury, which is part of my job as an attorney for a criminal case.
Okay. And in that trial, Grant Jones just testified that in Mr. McDuffie's trial that they were going over to Mr. Porter's for a drug transaction. Do you know that?
Do I know that he said that?
Yes.
Okay. I believe it was concluded that he said that. Yeah.
Okay. And he said that on direct and redirect. Is that correct?
I don't recall specifics. And again, I was not there for the entire trial. I do have other cases in other courtrooms.
Okay. So, I'm sorry. You could have taken that information of what he said, hey, we were going to Mr. Porter's for a drug transaction and not a lick. You could have impeached him being Grant Jones, with that information from Mr. McDuffie's trial.
That is one option. Yes.
Okay. And you wanted to impeach Grant Jones. You wanted to ruin his credibility for the jury. Is that fair to say?
I could have used that method, yes.
Okay, but it was your objective to convince this jury that Grant Jones is not a credible person. Do not believe his testimony.
My entire purpose was to defend my client and to show the reasonable doubt with him. That was my focus.
Okay, and by showing reasonable doubt, you argued to the jury that Grant Jones is not credible based on inconsistent prior statements. Is that one way to do it?
It could be.
Okay. How many times did you discuss with Brian Miley whether or not to testify?
I don't recall the exact number. I think I had at least 4 or 5 meetings with him.
And did you go over with him kind of a, for example, mock, going back and forth, what his testimony would be like?
Well, I gave him what normally criminal defense attorneys do. I asked him about testifying himself, and I advised him of the question that is normally asked when it's a state prosecutor asking, have you ever been convicted of a felony punishable by more than 1 year in the state prison system? And then when the client answers that question, if he says yes, then the follow-up question is, how many times have you been convicted of a felony punishable by more than 1 year in the state prison system? If the person gives the accurate number of convictions, then that's it. That's all the state can do. But in this case, the prosecutor had 20 certified convictions of burglaries and grand thefts and other theft-related matters. And I knew that. I asked for it, and he said he had it. And I advised my client that that is the process that a state attorney would put upon him if he ever did take the stand.
Did Brian Miley tell you what happened that night?
He told me his version of what happened that night.
Okay.
Yes.
Do you recall it?
I don't recall every minute detail, but I do recall what he was saying.
What was he saying?
I think the gist of what he said was, we were all over there to buy drugs. I was in the front seat. There was a fight in the back of the car, and that people were hit and pummeled. He denied hitting himself, even though some of the other affidavits said differently. He denied participating in the fisticuffs in the back seat. But he basically outlined what's been said, is that the guy ended up in the car, he ended up getting beaten, and they threw him out after they moved down the road a bit to get away from the apartment.
Did he tell you how Mr. Porter ended up in the car?
It was discussed, yes.
And he was reminded to say Mr. Porter got in the car.
He got in the car. He apparently didn't feel safe in the parking lot. This is his interpretation, my client's interpretation.
Right, that's what we're asking for.
Yeah. The drug seller or the drug dealer, Mr. Porter, wanted to sell drugs, but he was in the apartment complex parking lot where other people could walk and come and go to their places of residence. And basically, he got in the car because he thought by going away from where other people were, nobody would see what happened.
Right. So, I mean.
And then they threw him out after they beat him up, basically. Okay. That's the gist of what his version of it was.
All right. I don't have anything further. Thank you.
Stroke Street?
Yes. Either Dustin Stevenson, who represented Mr. McDuffie, or Sarah Kowinski, who represented Cheyenne Bentley, come to you and say, hey, my clients really want to testify for Mr. Mike.
No. And if they had, I certainly would have remembered it.
Okay. Now, counsel asked you about the trial of Mr. McDuffie and what was admitted or not admitted when Mr. Jones testified. If Mr. Jones testifies that Mr. Miley made the statement, that's an exception to the hearsay rule, correct?
I believe so.
All right. And then there's also the exception to the hearsay rule called co-conspirator. So if all of them were conspiring to commit a crime, again, the statement could have come in, correct?
I think so.
And in your experience, when multiple people are involved in the commission of a crime together, the state's going to ask for a principal theory, correct?
Yes.
And so whether or not, in reality, Mr. Miley was there or not there, hit somebody or didn't hit somebody, if they all conspired together to commit a crime, they're a principal, correct?
They were working together.
All right. So counsel asked you about, putting Mr. Miley on the stand. Is it ever your job to disprove the state's case?
It's ever my job to
Do you ever have a burden in a case?
Well, if I can present reasonable doubt and the jury buys that or is able to do that with the factual testimony we have, then I've done my job.
Right. But is there a requirement that you take the stand to give a defense?
Absolutely not. And he's informed of that as a legal right.
Now,
We had a hearing on that.
how long have you practiced here in the 14th Circuit?
In the 14th Circuit since 2001.
All right. And what jobs have you held as a lawyer in this circuit? Have you been a prosecutor before?
I've been a prosecutor here.
Have you been a public defender?
I've been a public defender here.
All right. And have you been a private defense attorney?
Yes,
Okay. So criminal law is, you're very familiar with, correct?
yes. And before here, I was a prosecutor in South Florida,
And how long were you a prosecutor there?
18 years and 9 months.
And so, in your experience, have you also had occasion to deal with me in court?
Absolutely. We've had murder cases together and we've had other things together.
Now, had you served your client up to the stand, the 20 felony convictions, how did you see the jury reacting to them hearing that Mr. Miley had 20 felony convictions?
I would anticipate the jury to be very negative and possibly not believe a word out of his mouth.
Whether they occurred on one day or over the course of years, would that have mattered to the jury's mind in your experience here in Bay County?
No. He chose not to testify. I advised him he had a right to do that. But I also advised him of anticipated reactions that we've already discussed in detail here in court.
And in fact, the court had a colloquy with your client, correct?
Prior to getting things started and having the trial. And by the way, the trial date that I have for Mr. Miley was August 14th through August 17th. It was not June 27 or whatever you put in your motion.
All right. Well, Mr. Peacock, when I asked you about Ms. Kahida, if you had called the witness to say that she simply did not remember anything that occurred, would that have been of any benefit to you?
No, to put a witness that said I was high as a kite, when all this went down, I don't think that would be beneficial to my client at all.
Ed, not really. They didn't list them, but they said that most of them were theft cases. I think they kind of summarized it. Well, you know what? They're going to call the defendant to the stand after the attorney's over, and I think that they don't go through them singly, but they said like, what are your charges? And you'll say like, I've got 10 theft cases, 5 whatever. So that does happen. Oh, while I'm paused though. Phil, thank you so much for the late fee for Bill. I appreciate it, Phil. Thank you.
And because you also had the complete discovery in the case, you were aware that if, let's say, Ms. Bentley magically agreed to testify, there were text messages she had sent afterwards, correct?
I believe so, and those would not be helpful.
Right. And you would agree that routinely in a case when there's flight involved after a commission of a crime, the state uses that as consciousness of guilt, correct?
Yes.
Now, we just saw Mr. McDuffie here. Do you think that would have been a great credible witness to put on the stand in defense of Mr. Miley?
No, he was the muscle man. He was the guy more than able to willing to beat on people.
Now, because the jury would have not seen Mr. McDuffie or heard from him, Is there a thing called guilt by association?
Yes.
All right. Do you think it would have been wise, even if magically Mr. Stevenson, now Judge Stevenson, would have agreed, hey, yeah, you can put my client on the stand? Do you think that would have aided Mr. Miley?
Not at all.
And the jury would have been entitled to know that he had just been found guilty at a trial, correct?
Yes.
Now, counsel also asked you about this Honda Civic, and you and I, we talked a little bit on the phone before this got started yesterday, correct?
About the mechanics of the child care or child safety seat, yeah.
And counsel asked you that you can go online, and in fact, that's what I discussed doing, correct? I went online about manual.
Yeah.
And it displayed the child locks, correct?
Yes.
And you heard Ms. Bentley talk about, in fact, there were child locks on her car.
Yes.
All right, so this whole talk about the locking mechanism, would you agree that the really relevant issue was, does the car have child locks? And because Mr. Jones has said that Mr. Miley had got out and activated the child locks, would that have been the relevant portion of concern about this car?
Yes.
Now, correct me if I'm wrong, throughout the trial, you did try to impeach Mr. Jones numerous times, correct?
Yes.
And you attempted to show the jury that possibly he had a deal with the state and that he had motivations to contrive and make up statements, correct?
At the time, I thought he did have a deal with the state.
Right. And correct me if I'm wrong, Mr. Jones had also given a statement to the investigating officer, Christian Williams, is that right?
I believe that's accurate.
Where he had discussed the fact that they were going to do this lick or get a lick, correct?
That was the term that was used.
All right. So that he had given that statement to law enforcement long before the prosecution had ever been involved in the case, correct?
I believe that's correct.
And he had indicated what the various people in the car had done, is that right?
Yes.
And he had told that to law enforcement the day he was arrested.
Yes.
Now, counsel asked you about this independent act defense. Are you required to put the defendant on the stand to try and get a defense?
I'm not required to put him on the stand. That is a total decision on the part of the client, and he was told that.
All right. And so, did you have any evidence in the case that was going to lend you to asking the court to provide an independent act defense where there was no evidence of it?
I found no reason for that to be included.
All right. Now, I asked you, but what if Mr. Miley had gotten on the stand? We can deal with a lot of what ifs, correct?
Yeah, we can speculate all day. We can sit here and, surmise all kind of things.
But in your experience as a criminal defense attorney and a prior prosecutor, based on the facts and evidence of this case, and coming off the heels of this case being tried just a week or so before Mr. Miley's case, was it your opinion and your recommendation based on all those years of experience as a lawyer to have Mr. Miley not take the stand?
My suggestion to him was it would not help him to take the stand. It would harm him.
And was it explained to him, not only by you, but also by the court, that it was his decision and his decision alone whether he would take the stand?
Yes, we had a separate hearing about that.
And he decided not to take the stand. Correct?
He decided not to take the stand, and I believe that is what he advised us to in the courtroom.
Since we're dealing with speculation at this point, do you believe, sir, that based on your
Objection
conversations,
to the characterization of speculation.
based on your conversations with Mr. Miley, having known about the outcome of Mr. McDuffie, and the lack of any, and knowing all the facts and evidence in the case as it proceeded through the trial, do you believe that if Mr. Miley had taken the stand, it would have been any benefit to your case?
I think it would have harmed him.
Not further.
You reiterate?
Do you recall that Grant Jones said Julia Kaida was not at Brian Miley's mother's house prior to the incident?
I don't recall that specific. If you have a transcript, and I'll be glad to look at it, I don't recall that specific.
Okay. Did you tell Brian Miley, it's my recommendation that you don't testify. However, if you don't testify, I cannot make an independent act defense on your behalf.
I cannot what, sir?
I cannot assert an independent act defense to the jury if you fail to testify.
I did not use those exact terms of independent. I did not.
Okay. Now, the state, when they asked you questions, the way they characterized their case as its principal theory. Everyone was involved, everyone acted in concert, right? And it was your goal to try and show that this wasn't a premeditated, everyone acting together, that this happened independent and apart from my client. Is that fair to say?
My objective was to take the facts and create as much reasonable doubt for my client as I could accomplish. I think that that is well within the bounds of what a criminal defense attorney is entitled to do.
Okay.
If I can do that with facts, evidence, or testimony, I do it.
You had seen the the Facebook messages between James Porter and Cheyenne Benton, correct?
I think some of those were revealed initially.
Okay.
And Mr. Porter was an active drug trafficker, in my opinion. I think I even suggested that to the state attorney at the time. However, since he was the active participant and then turned out being a victim of what he was, they chose to charge all these other people anyway.
Okay. And you saw these Facebook messages between Cheyenne Bentley and James Porter setting up this deal, correct?
I don't specifically recall the verbiage or the detail, but I did know about it.
Okay. Because in your cross-examination of Mr. Porter, you brought up the communication, is that correct?
I believe that is accurate. Again, I was trying to implicate Porter as being a bad behaving person too.
Okay. And at the end of the communication, do you recall Cheyenne Bentley saying, almost there, pulling up now, and then the last thing in this chat, is what it's termed as, is Mr. Porter responding, question mark, room in the car, question mark, this you backing in?
Do you have the actual document? I mean,
I do.
the verbiage that you just read, I'm not 100% sure.
All right, would you like to see it?
Well, that would be a good start.
Sure. And the last two communications here.
This appears to be a communication between the alleged victim, who was a drug trafficker, and the young lady who was trying to buy drugs. That appears to be accurate.
All right. Do you think that it's an important fact that it was James Porter who had the idea and wanted to get into the car?
I can't get into the mind of what was going on with Mr. Porter. He could barely speak because he had a speech impediment. And I can't visualize or get into his mind on that. I can only rely on what he put in writing and what he said in court.
Let me better ask my question. Do you think it mattered to this jury whether Mr. Porter is the one who was insisting on getting into the car as opposed to a plan of Mr. Miley and his co-defendants to get this guy into the car?
I'm not going to speculate on that. I mean, I don't know what he was doing or what he was thinking other than what he did and what was sworn to.
I'm asking to you with those facts in mind, do you think it's an important thing to focus on, you as the defense attorney, to the jury? Let me try and rephrase so I can be more clear. The state's theory of the case was this is premeditated. We want to get him into this car, put the child locks on, have him trapped in there and rob him, right?
That is your assessment
That is my assessment of the state's case.
That's your assessment, sir.
Do you see it any different as that was part of the state's case?
I don't know what the jury's assessment was, but I know what the evidence was.
Okay. Is that your assessment of what the state argued to the jury?
I'm not going to argue what is in the mind of the state attorney. Okay, I don't know for sure.
Hold on. Mr. Peacock, let's move this on. That's not the question. The question is, what did you think the state's theory was? That's the question. If I'm wrong, tell me.
The state's theory is that this group of people decided to take advantage of a drug seller and beat him up and throw him out. And they did it as a unified group of people. They worked together to get it done. That's the state's approach.
Correct. And they, by saying we're going to do a lick and doing the child law, those are preemptive steps to set up that plan. Correct? Is what they argue? The state?
I don't see that as a preemptive. I just look at the evidence. That's what happened.
Right. Preemptive meaning they took steps ahead of what they wanted to do in order to execute a plan. That's what I mean by that.
Those 4 people did that.
Okay. Now it's different if the jury had evidence to say this whole preemptive issue is false, where in fact James Porter is the one that insisted on getting into this car. And in fact, he got in and out of this car multiple times and chose his position. And he asked for them to drive away, as opposed to the state's theory where they said, no, one of the other co-defendants said drive away. Do you see a distinction in those 2 pictures that are being painted?
I see the 2 pictures and you do too, but the jury saw what testified and what evidence was there. And they concluded that they worked all together as a unit, 4 people, to commit the acts they did.
Yes, I agree. And my point is that certain things should have been presented to them so that potentially they could have reached a different assessment, correct?
I can't predict what the jury did. That's my answer. The jury heard what was testified to under oath.
Okay.
And they made a decision.
You had these Facebook messages. Why didn't you argue to the jury, hey, this was James Porter who wanted to get into this car. This is him saying, I need to get into this car. He's the one that wanted to drive away. He's the one that wanted to go into the gas station. Then all of a sudden, on the way to the gas station, some nut job in the back decided to go berserk, and this all happened, and my client had nothing to do with that. He just wanted to make $20 off drugs that night. Why didn't you do that?
Sure, you can speculate all you want, but the testimony was what it was. And these people worked together to commit what they did.
Okay, so if I understand your answer is you believed your client guilty, so you just decided not to defend him.
That is not accurate at all.
No?
That is not accurate.
Okay, so why didn't you present the argument that I just made to the jury?
The arguments were presented that my client was not
I
involved.
know it was presented. I'm asking you, why did you not present the argument I just made?
Well, I appreciate your creativity and your, forestic or futuristic thinking, but I know what the case file said, and I know what the witnesses said, and my client suffered the results of that.
Let's move on. That's the answer. Let's move on. Ask if you have another.
I have nothing further. Judge.
Any reader?
Oh, wait, one other. There was a jury question. Do you recall that? A jury question?
I don't independently recall the jury question.
All right, if I show you a copy of the transcript, would that refresh your recollection?
If you have an accurate copy of it, I'll take a look at
All
it.
right. Page 238, line 7 is the question. All right, Coach.
Yes, sir.
This appears to be a transcript, and it appears to be page 238. You're talking about lines beginning at 7.
Yes, where it says the other question.
If that's an accurate transcript, then that's it.
Do you recall a question being asked by the jury?
Now that you have brought that to my attention,
Okay,
and assuming this is accurate, yes,
all right. Does it refresh your recollection independently of it?
it does.
Okay, they had a question about intent, is that correct?
Why don't you just read it, sir?
Sure. Line 7, page 238, starts off with question. Can the judge please, I don't know what the word is, clarify intent for both counts? And can someone bring us some water? And judge, please come. Can you see what that is? They want to clarify intent. And the clerk responds, looks like come. Can the judge come clarify intent? Line 13, the court responds, I'll bring them back out, tell them they've got all the instructions I can give them. And if they want some water, we'll get them some water. We'll bring them back in with that. And then the jury enters. So they had questions about the issue of intent in this case. Is that fair to say?
Your Honor, I'm going to object as to the relevance of that decision.
I'll allow the question, but let's move on.
Okay. They had a question about intent. Is that fair to say?
If that is an accurate transcript, it appears that they did.
Okay. That's it, Judge. Thank you.
Any other questions?
Just briefly, Mr. Peacock, were you aware that even at trial, Mr. Porter testified that the people let him in the car? That he had testified about the one gentleman getting out, putting the backpack in the trunk, and then letting him in the car?
Yes.
Okay. So there wasn't some big difference between him saying he was going to get in the car. He didn't say anyone shoved him in. He said he got into the car willingly, correct?
Yes, he did.
Okay. That's perfect.
All right. Anything else?
No, thank you.
Can the witness be excused?
Yes.
Are you going to call him?
Subject to recall.
Are you subject to being recalled, Mr. Peacock?
Can we take a?
Yeah, we're going to go ahead and take our morning break. Let's take a 10-minute break, a real short break. If you need a break, they'll take you back in the back for your break, and we're going to start back in 20 minutes. That'll be 11:22.
22.
Yeah. 10 minutes. 10 minutes. 10 minutes. 10 minutes. We're all present.
All right. That's what we're going to call it for tonight. We that was fun. I told you that was going to be fun. You put an attorney on the stand. We still have a lot of this case to go. We are at 2:12:56 in the entire video. Hold on. The entire video is 3:49. So we still have an hour and a half left. So the rest of it's going to be played tomorrow night. I think this is a good time to pause. So tomorrow night, the defendant is getting on the stand, and that's about as much fun as what we just saw. So there's going to be a lot of back and forth. Yeah, but I think this is a good place to pause it. I don't want to stop mid questioning. So yeah, no, it's perfect timing. So thank you guys for watching. I do appreciate it. Thank you for the super chats, the membership milestones, the gifted memberships. You all are awesome mods as always. Thank you so much for your hard work. I do appreciate it. Big In, thank you for the raid. That was awesome. Speaking of raids, I need to go somewhere. Hold on. No, that's my video from last night. Why do I still have my video from? All right, hold on. This is going to take a second. Who we going to raid? You know what? Let's go to Katie Zed tonight. We'll go check out Katie Zed. She told me she had some really kind words for me earlier during grammar school stream. So we'll go raid Katie Zed tonight. Yeah, we'll do that. All right. Thank you guys so much for watching. Go tell Katie Zed I said hello, and we will finish this up tomorrow. I don't care how long the stream takes. There's about an hour and a half left. If we go for 2 hours tomorrow night, we go for 2 hours tomorrow night. But it's a good time to pause. So go tell Katie Zed I said hi. Thank you again. And that's it. Oh, I got to load my outro. I am awesome at this. I did just start my channel yesterday, so you gotta expect these delays. All right, we're out. Okay, bye.